No, Charlie.
All right. We have a new panel member. To my left is Judge Wallace. I'll not reintroduce myself and Judge Lambert, so we'll proceed with the last case on the docket. So appellant may proceed.
Thank you, Your Honor. Mac McLeod from St. Augustine. I represent the appellant, DWQ. Your Honor, we have a rather lengthy brief as far as issues in this case. There's 5 separate issues which we believe each standing alone would merit reversal, remand and/or reversal.
Issues 1 through 3 and then 5, were those properly preserved with the trial court?
I believe so, Your Honor.
Was there a motion for rehearing that was filed with the trial court for those specific issues?
Here's the specific way that went down. We did not discover the issue in issue 1, that is that the DVD had never actually even been opened until after the appeal had occurred. The appeal was already filed. During the course of there was a dispute with respect to the record when we went to check the record as to what was actually there because there was some confusion. This was discovered, and not until January of this year. We at that time filed 2 motions. We filed a motion, we were outside the 10 days, obviously, on the normal motion for rehearing. We filed a 1.530 motion for a new trial based upon that, and concurrently, because of the facts alleged in that motion, also filed a motion for disqualification. Prior to any ruling on the 530 motion, the court rendered a ruling on the motion for disqualification, commenting on the facts, that is, making factual findings in that. We immediately then and timely filed a petition for writ of prohibition to this court. This court denied that writ, and understanding that the 530 and the circumstances would essentially be fruitless, we went forward with the appeal on that case. But I think it is preserved on appeal in the circumstances, but notwithstanding, unquestionably, the DVD was never reviewed in the circumstance.
If we don't accept your argument that it was preserved on appeal, then would you be seeking to advance a fundamental error?
Absolutely, and I think we do in the brief that it's fundamental error not to review evidence in the case, and the fact that the DVD hasn't been opened and arrived in that condition at this court is evidence that it hasn't, that there's fundamental error, that is, admitted evidence that was indicated by the court would be reviewed, was not reviewed.
And there was, in the trial court, there was at least a reference to a transcript of the CPT interview?
That's correct.
Was the transcript ever entered into evidence with the trial court? It
is in evidence. It is a record in this case. There is nothing in the order indicating that the transcript was read either. I mean, I can't tell you whether it was or was not because it's simply a transcript, but there's no evidence in the record. The evidence in the case is the file never left the clerk's office. But that said, there's no evidence in the order that the transcript was ever read.
The transcript is in evidence?
The transcript of the DVD is in evidence.
Or is just filed in the court file?
No, it's in evidence in the case. It's a marked exhibit in evidence in the case. That's one of the issues we went back to the trial court to make sure we were clear about, and the trial court indicated such was the case, that and the DVD had been marked into evidence. They're a part of this record on appeal.
Who moved it in evidence?
I did.
You did?
I did. Along with the Child Protection Team report, along with that transcript and the DVD. And the DVD is a single, non-duplicating, you cannot duplicate that copy of the CD because of the safeguards put by the CPT on it.
So the transcript is a complete transcript?
It is an absolutely...
Transcript in evidence?
Yes, sir. It's an absolutely complete transcript, and that's in the case. Our argument on that issue was because of the evidence in the case, and that is she demonstrates what occurs. She actually, in the video, in the DVD, says this is what occurs. occurs, and she backs up and goes like this. That's her motion, and she does it twice in there. Then in order to, that doesn't interpret into a transcript because she says this is what he did. And in that circumstance, the DVD was crucial. I say it in the trial. I say it at the very end of the trial on 2 or 3 separate occasions. I cannot rest until the court views this DVD, until I think we play this DVD. The court says, I'm leaving at 5. It announces that at 1:20-something when we started. We get to 5 o'clock, we're not finished. I said, I have to do that. He basically says, I'll look at it, put it in evidence, and then I say, I'm going to seal it in this envelope. And if you look at the record, or whoever looks at the record, it's in what's known as a rip-proof or rip-stop envelope, and I did that on purpose, not because I didn't think the court, but it's such an...
You don't know do you know whether or not the trial judge reviewed the transcript? Do you know that?
I have no clue. There's nothing in the order about it.
But in order to satisfy the requirement that the trial judge review all the evidence and testimony, would the trial judge have to review the transcript and the DVD? If the transcript is the transcript of the DVD?
I believe that your review of the transcript will not provide the evidence that we believed was absolutely crucial. That is, look at the demonstration of what the child said, as well as the demeanor and the absolute confidence of which this child says, this is what happened, this is the only thing that's ever happened, this is the only time it's ever happened, and she's quizzed specifically by Child Protection Team on 2 separate occasions. Has he ever touched you in any other inappropriate way at any other time? Her quote is, and very confident and very maturely for a 10-year-old, says, absolutely not, never. And she shows what occurs. And that's why we believed it was absolute that you have to look at the DVD to appreciate...
As well as the transcript made in the first place.
The transcript was made of the DVD because I wanted a copy of it so as to ask her questions and cross-examination about it. I got the transcript of it.
Is this the packaging of the DVD?
It is.
Okay, and is this your handwriting that's on the front of the envelope?
No, it's not.
Whose handwriting is that?
It's either the clerk or a paralegal. I think it's the clerk of court wrote that.
Okay, and it says, Quinny, DVD important, please protect.
That's right.
It's not your handwriting.
It is not.
And there's an exhibit sticker?
That's right.
All right, would that have been prepared by the clerk as well?
Yes, sir.
Okay, so the handwriting would not be your handwriting or anyone from your office, correct?
I don't think it's anyone from my office, no.
Okay, and the back of the envelope doesn't appear there's any writing on the back of the envelope?
Not at all. That envelope's exactly, it looks to me from here is exactly as it was when it was introduced into evidence. You'll notice on the back of the envelope, there's a place where you have to rip it open. And so that kind of goes to issue 1 in this case. We believed it was and the case law says, because of the fundamental liberty interest involved, that due process requires you listen to the defense of the person who's about to have their parental rights taken away. And some of the case law that we've cited in the brief says, even if the court wouldn't find it compelling, you owe us the opportunity to at least look at it. All of those cases, frankly, those are refusal cases. That's where the courts in the Julia case says, it's 5 o'clock, I'm not hearing anymore. Those are pretty obvious. In the other cases, it's just, I don't want to hear it, I don't think it's going to be relevant, keep going. Those are cases that are reversed on due process. This case is different. In this case, we are told by the trial judge, I will review it. I will look at it in the circumstances, which is the only reason we would have allowed the case not to go forward. I mean, there's nothing I could do at 5 o'clock. That's crystal clear from the record. But in the circumstances, of course, there would have been vehement objections. I've been doing this for a while. You've got to make sure the evidence is in. When a trial judge tells you, put it in evidence, I will look at it, I will review it, and we say in the record, I even ask an expert, how crucial is it that the judge looks at this, and the expert says it's very crucial that he looks at it. And then he says he's going to look at it. I don't know whether, I'm not trying to demonize this act. Whether he did or did not, or whether he forgot or just didn't do it because he didn't think it was important, or perhaps as is perhaps speculated in the case that he read the transcript and thinks that is enough, even though the order says nothing about the transcript and the circumstances, it is what it is. It's never been looked at by the court in the circumstance. It's evidence. It's akin to, I'm in a criminal case, I've got an alibi witness that totally alibis my client. The judge says, we'll hear it, and then dismisses the jury. The alibi testimony comes, and the jury comes back, and they render a verdict. I mean, I know it's a gross analogy, but that's what occurred here. It's never been looked at. And the reason why it's important is this court, I believe, has de novo review. I know that's argued, but I think under two reasons it has de novo review, because of the liberty interest involved in parental rights and because of the due process issue pitched in issue 1. But the fact of the matter is, if this court looks at the DVD, which I think it has the absolute right, if not duty, to do, it will be the first judicial eyes on that DVD. In fact, I believe it'll be...
What you're suggesting, if we look at it, then what? We're not the ones who are the finders of fact.
If it's de novo review, Your Honor, I believe that you have an opportunity and a right to independently review the evidence to see if it meets the clear and convincing burden required.
The trial judge did not properly review the evidence that was presented in the case, and therefore the order, the judgment we're reviewing is invalid, needs to go back. I mean, we're not going to, I don't think it would be for us to take a look at the DVD and come to conclusions of fact, and the trial judge should have done that in the first place. You send it back and let him do it, right?
I think you can do that in all candor.
We've not seen we didn't watch any of the other evidence, so I mean, how could we look at this piece of evidence and then reach some conclusion when all we have is a cold record as to the other evidence?
Understood. This is the only evidence that has to be watched. All the other evidence is essentially read in the record and in the transcript and in the Child Protection Team report.
I mean, it's live testimony.
Sure.
The judge is evaluating the credibility of whatever witnesses are testifying. We get the record and we have a different review standard about what judges...
I understand that. In this case, I think it would be, again, I'm not trying to speculate, but if it gets remanded for the judge to do what he said he was going to do, it's my suggestion in the circumstances that present here, since he's already made some sort of comment in the circumstance, it can be remanded to the court. We're going to be in the same place we were before with the same situations, trying to get another judge to look at the circumstances in the case.
It goes back and it's remanded, and following your argument in your brief, saying, Judge, you look at this evidence, you have to decide whether a TPR should be granted based upon the grounds pled, and then you have to follow, set forth the 11 factors under 39A10.
Right.
And we send it back for the judge to do that, and the judge does that. Isn't that his...
I don't think the evidence is ever going to change in this case. I still don't think there's clear and convincing evidence, notwithstanding the DVD from the transcript. I don't think there's clear and convincing evidence.
Different appeal then, I guess.
Sure.
In theory, you'd be saying, okay, he's now done all these things, he's issued a new order, and we don't think that the order, based on the evidence, is supportable because it was not clear and convincing evidence to judge, there's not competent evidence, et cetera, et cetera.
Well, I don't think it's lost on anybody in this room that will give this court the opportunity to correct at least 3 or 4 errors in this case. He does not set forth 11 the criteria that you have to, along with anything else he believes is relevant. He gets 2 out of 11, and there's no case law that says anything other than you have to do that given the rights involved. He absolutely changes, at the first time ever, he quotes 806F, which has never been pled in the petition, is never argued an opening statement by counsel. I moved for a directed verdict at the time based upon C, which was never even argued in the case, and then G, and primarily because of least restrictive means, which this court, Judge Sawaya in the 5th, has said is so fundamentally required except for the most egregious cases. We'll talk about that in a moment. But in that circumstance, then he can go back and do all, set forth the manifest best interest requirements. I don't know what you do with the fact that he found it on subsection F, given the fact it was never pled, and it was essentially a creation at trial that he used to get over the least restrictive means format or circumstances in the case. And then we're still going to be left, however, with the issue of clear and convincing. There is no more evidence, although I'm not trying to be glib in this case. Who knows? Because the evidence has changed so dramatically from 2010 to the time of the petition in 2013, and then even in late 2013 at the time of the petition to the time of trial in 2014. This young lady, now child at the time, diametrically changed her position as to things that occurred, even that she wanted to see her father still in 2010, and we get to 2014. I mean, Judge Alexander, one of the things in the order we have particular agreement with, he says this is obviously a, quote, crusade. Well, unfortunately, a lot of things happen in crusades that probably should not happen, and this is certainly one. Something has happened to this child from 2010, which even if you read the transcript, it's clear she is not so affected by this, she doesn't want to see her father anymore, and then it changes. So,
citing all those inconsistencies, even more evidence or more support for the fact that trial judge is the one that needs to be reviewing the DVD, not us as the appellate court. Trial judge is the one who's eyeballed and listened to the testimony from the witnesses at the original proceeding.
Sure.
And now, it ultimately, you're going to have to weigh all of that to come to a proper decision.
I guess I have a personal reservation would be the professional way to say it about sending this back to Judge Alexander to correct what are such obvious mistakes, but particularly because of the allegations in issue 1 in this case, I don't have a real chance of any change of decision by an independent magistrate or judge in this case. Let's be candid. He's not going to come back and say, okay, yes, I didn't do that. If it's remanded, I would ask that it be remanded to the court, but to another court, to another judge. That's the only real way this individual is going to get an independent review of the evidence and due process afforded. Look, the courts call TPR the death penalty of family law. I don't think a death penalty in family law, a termination of parental rights, such an inviolate liberty issue in the circumstance, should be weighed by anything less than somebody totally independent.
I mean, in murder cases or death penalty cases, if there's an error is committed by the judge, and assuming he or she is still in the felony docket, we wouldn't just send it back and say, okay, Judge, you committed these evidentiary errors or rulings, et cetera, and we're reversing the murder conviction and sending it back, and we now to give it to a different judge because you really blew it.
I think you're right. I've been in that situation both as a prosecutor and defense attorney back in long ago in the 80s. I will say in a circumstance where there has been, like this, where there's been a representation made by the court that something occurred that so obviously did not occur, in that circumstance, I think any criminal lawyer worth his salt would move for a disqualification and would be in the same position with me that I am with you.
Is the disqualification issue an issue that's been raised in the briefs in this case? Or is
No, Your Honor, I don't think it could be in the circumstance.
What do we then have to say that, or what basis do we have to say that it should be heard by another judge if we remand it back?
I guess my immediate comeback with without a whole lot more research on that would be the inherent authority of this court to do that in these circumstances because it engages the due process issue.
Did you file a motion to recuse or not?
Yes, I did.
All right. And the recusal issue has not been raised in this appeal, has it?
No, it was not a part, I don't think it could be in the circumstance. It was denied, and I took it up on a writ of prohibition, and it was not heard. It was denied on prohibition before this court, and we took it up because he made a factual comment about the factual allegations.
You said that couldn't be an issue that was raised in this appeal.
We looked at it, and I don't believe it is a part of the appellate issue here. I mean, that's a decision that I made.
When was the motion to disqualify filed in relation to the entry of the order terminating the parental rights?
The termination for parental rights, I believe, occurred in October of 2014. We discovered the DVD issue in January of 2015. We filed at some time soon thereafter a motion under 1.530, and concurrently the motion to disqualify. Fairly quickly, the court denied the motion to disqualify, commenting on the facts made. That is, making a factual finding, which we didn't think you were allowed to do, and we immediately filed a writ of prohibition, which was denied, so we went forward with the appeal.
Well, once the order of termination had been entered, what was there to prohibit then?
I'm sorry?
If you say that the order of termination was entered in
October
of 2014?
Right.
And then you filed a writ of prohibition in 2015, prohibit what? If the order had already been entered, what's there to...
We're already up on appeal at that time. We had already appealed. The appeal was before this court at that time. The only issue was the record.
All right, well, you said that you filed a petition for writ of prohibition. I'm just wondering, what was there to prohibit if the order had already been entered? You can't prohibit that which has already been done. But, in any event, but you're saying you don't think you could have inserted that issue into this appeal?
We tried. It was hotly, we moved to supplement the record in this case with all of those pleadings, including the 1.530 motion, the motion to disqualify, and a clerk's certificate indicating what the condition of the record was. That was denied by this court. Yes, sir. I think I'm going to reserve what little time I have left.
We don't have much time left.
I know. Thank you.
An extra minute, and I'll give you an extra minute.
May it please the court, I'm Bill Grussley from Jacksonville on behalf of the appellee. At council table with me is Steve Alexander, who is trial counsel. I have to ask something I've never asked in 30 years. Can I approach and have Judge Wallace hold that DVD up again? Because I've never seen the original. I've got a copy of it. I'd like just to see what it looks like.
We're not here at an evidentiary hearing, but...
I guess it's the evidence sheet.
What is your response to the argument that the trial judge never considered the DVD? Why don't you address that first?
I was going to. I am amazed at the conversation I've just heard, because I understand Mr. McLeod's passion. This is the first appeal I've been in 30 years where every single brief has been amended. Mine was stricken by order of this court because the very thing that he brought up to start with about the subsequent proceedings and the entire conversation that the court just had, the colloquy, about what happened with this writ of prohibition, I said, wait a minute, this judge has already made a ruling on that.
Well, the writ of prohibition, I'm not really...
I understand, but the judge has already said in an order...
The issue is not an issue in this case, but there's an argument that the trial judge denied them due process because he did not consider all the evidence, which is the DVD. So,
and I understand. My response to that is that it is not a fundamental denial of due process. The analogy that I think of is let's suppose we have a jury trial and we have a video deposition that's played for the jury, and they're also given a copy of the transcript. One of the jurors goes to sleep and doesn't pay any attention to the video. Is that a due process violation? No. It's a question of what the juror, the finder of fact, is allowed to...
Do you contest their assertion that the trial judge did not consider the DVD?
If I can address the order he entered, he said he reviewed all the evidence after the fact. I cannot tell, and I will accept that envelope doesn't look open, but I cannot tell that. I think we're making assumptions that it wasn't looked at, and more importantly, let's assume that it wasn't looked at.
What evidence do you have that it was looked at?
Because it was put into evidence, the judge at the end on the transcript,
When it was put into evidence, I think the representation or the request was made by counsel for the appellant that he couldn't rest until the judge
Absolutely.
looked at the DVD.
That's correct.
Then it was sealed, it was announced on the record that it was going to be sealed, and then the judge made the representation, I will look at the DVD before I enter my ruling.
The exact representation the judge made is give all the exhibits to the clerk who sits in the courtroom in St. Johns County, and she will get them to me and I'll review all the evidence. That's as far as this record shows what happened. I cannot make any further representation. My argument is that it's cumulative and duplicative. This entire animated display that Mr. McLeod just put on is his interpretation. It was his testimony about what this DVD is and whether it's exculpatory. This judge, I think it's important that we keep in mind, and the order under review says this explicitly at the outset, and I'm paraphrasing the judge, but I have been involved with this family for years. This is the third case I've had involving these people and their child. There was a dissolution case that ended up with one procedural decision out of this court. There was then, once the allegations of the sexual abuse and the other abuse came up, there was an injunction case, and the judge said, in the order, I refuse to issue an injunction until, because of the acrimonious divorce case, in my experience in this case, I wanted some kind of independent verification. I wanted a report from the Child Protection team before I would do anything. And so that is the context for what we're talking about. I spend my life doing family law.
You're saying that you make no representations one way or the other, whether the trial judge reviewed the DVD?
I can't. It requires me to be omnipotent about whether that's the same envelope, the piece of paper on the top.
He doesn't say he did, and he doesn't say in his order terminating parental rights, I reviewed all the evidence.
That's correct.
He just says numerous witnesses testified, which is true.
Yes.
Voluminous documents were admitted in evidence during trial, which is apparently true.
I can't answer your question. I assume he looked
The
at
point
it.
being, is assuming, if we believe it's not been looked at,
I think it's cumulative and duplicative.
well, but Mr. McLeod is saying, I'm putting on my case, this is a crucial piece of my evidence that I want to play. I don't think that the judge would have the authority to say, well, I'm going to refuse to look at that testimony, just give me a transcript, if that's what he believes is how his order of proof wants to be, and the judge leads him to believe by his statement at the end of the trial, okay, I've got to go, but I will look at it. And so Mr. McLeod can't sit there and hold his breath and say, well, we're not going until you look at it, and he relies on that statement, and the judge then doesn't do it, or we believe the judge maybe overlooked it. We're not, no evil intent, he just overlooked doing it before he did it. How is that not a due process violation to at least send it back to say, Judge, if you want to do what you did in the order, you know, that's based upon your analysis of the evidence, and we'll see it on appeal if that's what Mr. McLeod wants to do, if his premonition proves correct that the judge doesn't change his mind. But you, at least from a due process standpoint, have to give both sides an opportunity to present all the evidence in, and then you make your call so we're comfortable that that's what you did.
And that's-
How is that not a fundamental issue?
And that's premised upon your finding, and this is certainly within your authority to say it's a question, and we want it answered. Send it back and say, Judge, did you look at it? And if you didn't, look at it and tell us whether it changes anything. My position in my brief is that the case law is clear, that it's cumulative and duplicative evidence is a harmless error at best.
But how is it duplicative of the demonstration and, I mean, assuming the trial judge looked at the transcript, as I'm sure you've argued numerous times, doesn't do justice to the tone and the way in which the questions are answered.
And that's true if you ever have a video deposition, for example.
Okay, so how is the DVD video duplicative of those two aspects of the exchange between the child and the CPT interview?
It is in substance. It's not the same medium, and I accept that. And like I said, this is the same answer that I just gave to Judge Lambert. If you think that that's an issue, and that it can't be duplicative, or you don't know, and you think that's critical, then send it back and ask the judge to look at it. That's the only possible legitimate answer I can give you. I would like to address the other issues that you raised about whether...
Get to the argument that the trial judge based his decision on a ground that was not pled.
That's a red herring argument, and it's also incorrect. The egregiousness under F2 in the statute is a conclusion based on the evidence. There's two answers to this. One is, what was actually done at trial. This was the motion for directed verdict. I think it's technically a motion for judgment on the pleadings in a bench trial, but Mr. McLeod made it. Courts, after he concludes, court says, okay, I find there sufficient grounds under 1F2, the egregious abuse, which includes, and he goes on, and it's also chronic abuse, including but not limited to both the digital penetration and the showering, adult male showering with a 7 or 8-year-old female to be consistent with chronic abuse, so the motion is denied at this time. Mr. McLeod asked, so you've made that finding? He said, no, I'm making that they made a prima facie case of that. At that moment, Mr. McLeod had the opportunity to put on evidence, object to this. None of it. It's not preserved. There's a case out of the 4th. Well, this court has twice recently held that if you don't object and you proceed with the evidence, it's a waiver. CB versus Department of Children and Families, cited in the brief. KS versus...
Basically saying it was tried by consent or waiver?
Yes, and here's the real key holding from the 4th that is dispositive of this issue as a matter of law. WS versus Department of Children and Families, it's in my brief. Failure to cite to the exact statutory reference for a ground for termination alleged in the petition is fatal. No, we reject that it's fatal so long as the substance of the ground is alleged in the pleading. The substance of these grounds are set forth in clear, explicit detail in the pleading. The term egregious under the statute that allows you to do without this least restrictive, or least whatever the term is, I'm sorry, is a conclusion based upon the facts. This whole trial was based upon the facts of the abuse that were ongoing. It was not, as has been argued throughout, some isolated incident. It is an ongoing chronic abuse that is fully supported by the evidence. It was not just this one instance. It was the showering and the straddling and the testimony from the child and the testimony of the child's therapist that had confirmed that this has been consistent for years, that ejaculate was found on her in the morning sometimes. That was explicit testimony, and that was what the judge found under the 2 provisions that were actually pled on the chronic abuse. If the conclusion is it's egregious, that is an inference that the judge can draw, and that's a conclusion.
But I mean, in paragraph 11 of the petition, the undersigned attorney submits TPR is authorized based upon 398061C and G.
Yes.
I don't know how the other ground that was actually the 1F ground could be tried by informed consent if there's some overlap in the evidence that might come under 1G.
It's the exact same evidence, and most importantly, if legally.
Well, if it's the exact same evidence, then there would be no basis for him to object to that evidence, but he certainly would have a due process argument to say, well, I know you would shake your head no, I'm
sorry.
Yes, that he can certainly have a right to say, well, wait a minute, you can't come in at the end and then say it's terminated under ground 3, which has not been pled.
It's not a different ground. It's a conclusion based upon the facts, and it's not an evidentiary objection. The judge said explicitly, before Mr. McLeod put on his first piece of evidence, I'm finding that this constitutes egregious abuse, a prima facie case of it. At that moment, that was Mr. McLeod's obligation to say, Judge, that's never been pled. Then we could have a full record on it. But we went through this whole trial, and we're hearing now in the brief that this was a surprise. It was not a surprise. It was explicitly explained to the judge at the outset of the conclusion of the petitioner's case and before the respondent put on its evidence.
The opening statement of Mr. Alexander that this is the ground?
I don't think egregious is any different than the facts that supported the other 2 statutory grounds. That's a conclusion in the statute.
398061G, sexual battery or sexual abuse.
It's chronic abuse.
Say, okay, I find the termination under these other 2 grounds as well as this one?
That's different. That's a different, because sexual abuse is different than egregious as defined under the statute. And it was explicitly put on the table by the judge. This is where I think they are. They've proven the 2 factors factually. And I find that constitutes egregious abuse. And the 4th DCA case I just read you said it doesn't matter if it's specifically pled as long as the facts are pled and you go prove it. And they had explicit, exact notice. It's the same issue with the failure to do the statutory citations. I cited the Wright case. I just happened to be involved in that one where the whole point of requiring specific statutory written findings is to facilitate appellate review. They didn't file a motion for rehearing say, Judge, you didn't make these findings. They raised that on appeal. They also have ignored the case law that says if you can glean it from the record and it doesn't impede appellate review, then it's not a reversible error in and of itself. And we've been through our brief. We went through every single factor and pointed out the evidence that supported it that's from the order under review and where in the record and where in the transcripts that evidence is found. It's not only not preserved, but it's not fatal. It is...
Setting aside that issue for just a minute and going back to the issue as to whether the trial judge reviewed the DVD, why wouldn't it have been expected, maybe appropriate, for the parties to ask this court to temporarily relinquish jurisdiction to go back to the trial judge, just so the trial judge can make a finding as to whether he reviewed the DVD or not? And then let us decide.
The other side asked for that and then withdrew it.
Pardon?
They filed a motion for relinquishment of temporary jurisdiction to have that issue addressed and then withdrew it.
They filed it and withdrew it?
Yes. And that, again, that gets me into the problem of talking about post-order issues. That's why my answer brief was stricken. I thought that was an appropriate thing under the circumstances to address.
Did you contest their motion to temporarily relinquish jurisdiction?
Mr. Alexander objected to their supplementing the record with all of this other...
No, I'm talking about, you said they filed a motion to relinquish just to...
And then withdrew it.
Yeah, well, they withdrew, but, I mean, did they withdraw because he objected, or?
There's nothing in this record that tells me that.
Wouldn't it be appropriate to perhaps do it now, even though we've had a little argument, and just temporarily relinquish and admit that the trial judge make a finding, I reviewed it, or I didn't review it, and...
It's within your authority to do that. I'm not clear that there's any precedent for saying there may be an evidentiary issue. It should have been the subject of a motion here to relinquish so that this can be resolved so we can get our record straight, but it was not.
I guess maybe a follow-up what Judge Soy is asking, when you're saying Mr. McLeod filed a motion to relinquish jurisdiction and then withdrew it, did your side, Mr. Alexander or whomever, file something in response to that motion?
I'm going to have to ask because would not be part of this record, at least the part that I'm familiar with.
And if how would it not be part of this record?
He did not object, he says.
I mean, if he filed the motion, wouldn't have Mr. McLeod have filed the motion here? So...
It should have been, and I apologize.
Alexander filed something, it would be here, it would not be in St. Johns County, responding to that motion.
I have seen the motion. I apologize. I can't tell you. It should have been filed here. That's the correct way to go about doing this.
If it's not in the record, we shouldn't be mentioning it.
Well, and that's been part of the problem with this whole issue, is that...
When I asked the question, I thought that my question was, why wasn't that done in this
It should have been.
court?
It should have been.
So you're saying you're referring to some motion that's not in the record?
There is a motion to temporarily relinquish... I'm sorry?
Is it in this record or not?
I'm sorry, I should know the answer to that, but I do not.
Okay, if it's not in the record, we won't consider it.
Okay. The other issue that...
Opposing counsel, why wouldn't it be appropriate just to do that now, if that's a dispositive issue in this case? Just temporarily relinquish, go back?
If you believe it's dispositive, if that's what you think...
I don't know. I mean, we've got these other issues we have to consider.
And I would like to address briefly the point that was made about not raising recusal of the judge on a regular basis. Part of the request for relief I make before this court and in the first, which is where I spend most of my life between the two, I make an argument that this court has the inherent authority, and there's plenty of case law, to direct on remand that there be a different judge to preside because either a judge refuses to follow a prior mandate or has demonstrated an inability or unwillingness to consider the evidence. That has not been raised here. This contention that, well, I can't get a fair shake, we had a prohibition, and you're right, it was of after the order was entered issues, but it was already presented to this court.
No need to talk about an issue that's really not an issue in the case any longer. That's a recusal. So anyway, you've got a little more time if you want to
Okay. Just a couple of quick issues. The clear and convincing argument that they've made essentially comes down to if I can make any colorable argument on the other side that it can't be clear and convincing evidence. This evidence that was believed by the judge was from the child's therapist, from the guardian ad litem, was clear and consistent. There's a fact that we have not addressed very well, and I'd like to point it out that the North Carolina incident, which was sort of the precipitating event for the child reporting, it was not the precipitating event of her abuse. It was things that she remembered later as she got older and could understand it. The child, the morning after this happened, first person she sees is the father's girlfriend, and she said, "I think Daddy thought you were in bed with me because he went to touch me," and then indicated where, which was her pubic area. And my question is, what 7-year-old knows what Daddy does with a girlfriend in bed? Why would she even say such a thing? Again, this judge has spent years with these children, with this family, has heard multiple depositions and arguments and motions, and has had 2 separate hearings, one on the injunction and one on the TPR, and is very familiar with all of this. Finally, this is my last point, is this least restrictive means is a red herring. They've had 4 years of least restrictive means. There is no other option here except to say, well, we can just keep this in limbo. And the child was adamant, the guardian ad litem was adamant, and the counselor was adamant that this situation is making this child emotionally and mentally distraught and needs to be done and dealt with now, which was the basis for their recommendation that it be terminated. 39.8101 says, and their theory was, well, you could make an order that says the grandmother, the maternal grandmother, could be the guardian if something happened to mom, and that's the least restrictive means, Judge. You shouldn't terminate. Subsection 1 of the statute says that that's not to be given any greater consideration than any other factor weighing on the manifest best interest of the child, and may not be considered as a factor weighing against termination of parental rights. The statute makes it clear that just because there may be some other thing out there, I think giving a grandparent a guardianship in advance when we don't know where anybody's going to be when, is not only completely at odds with the statute, but it also defies common sense in this case. This child has suffered. She has suffered egregious abuse as found by the trial court, which is supported by the evidence, which is a legal conclusion based upon the facts, and it should be affirmed. Thank you, Your Honors.
Thank you. You actually had about a minute. I'll give you
I think I have a minute.
Yeah, I'm going to give you an extra minute because...
Okay, thank you.
All right.
Judge, let's be clear on the procedural. There was a motion when this all came about.
My question is, why wouldn't it be appropriate to do it now? If there was a motion that was filed somewhere else and it's not in this record, we don't need to be talking about it. But my question to you and question to opposing counsel is the same. Why wouldn't it be appropriate for us to temporarily relinquish on our own motion and just have you go back to the trial judge and let him make a finding? I reviewed it or I didn't?
You can. You can do that.
Sorry to hear you say.
You can do that.
I can't?
You can. I'm sorry. We moved to relinquish. It was opposed by Mr. Alexander. It's in this record. Yes, in this record.
All right.
It was opposed by Mr. Alexander. We filed the motion under 1.530 at the same time because I had evidence of it, and filed the motion to recuse at the same time. Because the judge made a factual determination in the motion to disqualify, it was obvious that bringing the move to relinquish jurisdiction was fruitless. He's already ruled.
You filed a motion in this court, you say it's in the record, but then you withdrew the motion. That's objected, and then you withdrew. Okay.
I did. That's correct. This issue of the least restrictive means, the reason why they contended least restrictive means doesn't apply is because of this judicially created F issue, 806F, which was needed to overcome that. But it even applies in 806F cases, only the most egregious. They quote the type of case where it doesn't. Okay, where a guy marries his daughters and tries to have babies with them. Thank you, Your Honor. I appreciate your patience.
Thank you. All right.